Good evening, everyone. I'm Professor Sally Wheeler, and I'm Dean of the ANU College of Law and the University's Pro-Vice Chancellor for International Strategy. I'm delighted to welcome you to this evening's virtual discussion, the EPBC Act, Federal Environment Reform in an Age of Climate Crisis. I'd like to extend a warm welcome to our audience who come from across Australia and indeed further afield. I'd like to acknowledge and celebrate the first Australians, surely the world's most patient and forgiving people, on whose land and airwaves we gather today. We pay our respects to their elders, past and present. This year marks an important milestone, 60 years of law at ANU. And to celebrate this anniversary, the college has presented its Law in Focus programme of events, bringing together the rich expertise of our legal scholars, our alumni, and esteemed thought leaders. 2020 will, of course, be remembered for very much less favourable reasons, global mayhem, and in terms of our environment at home, the Black Summer bushfires burned nearly 20 million hectares and led to Canberra having the worst air quality of any city in the world for some weeks. The Great Barrier Reef was found to have halved in size over the past 25 years. And the Yukon Gorge, a sacred Indigenous site in Western Australia, was blown up by Rio Tinto to access iron ore. It's therefore timely for us to examine how federal environmental reforms can better protect our national landmarks and conserve vulnerable ecosystems and species. So now I'd like to introduce Associate Professor Matthew Zago, who is Director of the ANU Policy and Research Group, Law Reform and Social Justice, to say a few words about the group and its GreenLaw project before we commence our discussion. Matthew.
Thank you, Sally. I'd like to join you in welcoming everyone who's with us online from Canberra, Australia, and who's listening in on the podcast that will be posted to the college website. As Sally said, my name is Matthew Zago. I'm an Associate Professor here at the College of Law. I'm also the Director of the Law Reform and Social Justice Programme, which is co-hosting tonight's event. The Law Reform and Social Justice Programme, or the LRSJ, was founded in 2008 by Dean Michael Coper, and over the past 12 years, it's positioned itself as one of the primary vehicles for realising the college's express law reform and social justice ethos. It's become, for want of a better term, part of the DNA of the college as the National Law School, central to its identity, to its mandate, and a drawcard for prospective students and scholars alike. This evening's event provides us with an opportunity, as part of the 60-year anniversary of the college, to showcase and celebrate one of the LRSJ's core activities, and that is the student-led and often student-initiated projects, which provide a platform for law students, as well as some students from outside law, because we aim to be interdisciplinary, to work with academics, practitioners, advocates, and activists to influence public debates and even impact the development of public policy around major challenges facing us in the first half of the 21st century, and when it comes to climate change, far beyond. At any one time, LRSJ projects will have upwards of 250 students in one of a dozen projects working on a range of issues, writing law reform submissions, appearing before committees, drafting blog posts on the COVID crisis and the challenges to the rule of law, running workshops on legal advocacy and campaigning and submission writing skills, working with Indigenous elders on truth-telling and treaty making, collaborating with national NGOs to promote economic and social rights charters, or the setting up of preventive mechanisms under the optional protocol to the Convention Against Torture, interviewing inspiring alumni working in the sector, or researching pretty much anything from corporate accountability and refugee rights to modern slavery and religious discrimination, just to name a few of the activities that our students have been engaged in over the past year. Now, in ordinary years, we'd also have a steady program of seminars and panel talks and screenings, and every few years, a national law reform conference with a major publication. We also have had a vibrant visitors and mentorship program, and Justice Rachel Pepper, who's on today's panel and is an ANU alumna, came to Canberra just last year as an LRSJ visitor, delivered a public talk on environmental litigation, but also crucially met with students to discuss her career as part of our program of demystifying professional pathways into the social justice sector. 2020, of course, has been different. The program's moved online, but despite its many challenges, one of the most exciting things to have happened this year has been not just the vibrancy of the student projects, but more specifically, the extraordinary achievements of the GreenLaw project, represented this evening by one of our inspirational students and the project founder, Annika Reynolds. GreenLaw's gone from an idea in Annika's head to a powerhouse, multifaceted, interdisciplinary project in just over a year. And I'll give you a brief taste of what the group has been up to by way of showcasing their dynamism. They've been working with the Farmers for Climate Action project to provide background constitutional advice that will inform the group's development of a national strategy for sustainable agriculture. They're assisting the Antarctic and Southern Ocean Coalition, which is the only NGO working full-time to preserve Antarctica and the surrounding Southern Ocean, in researching international obligations under the Antarctic Treaty and the Law of the Sea, and that's supervised by Professor Don Rothwell and Jonathan Liliabad. They've developed an impressive practical guide to law and protests in the ACT, which is aimed at helping groups and individuals understand legal issues around organizing and participating in non-violent direct actions, supervised by Anthony Hopkins and Vivian Holmes. And one of my favorite projects, they've established something called a green tea program, which helps GreenLaw members with processing and coping with the emotions that invariably arise in the climate justice space. The team's already held 3 psychologist-led sessions this semester under the Green Tea banner, and they've received very positive feedback from students for how the program assists not just in grappling with ecological grief, but also with building a sense of community at the law school. Something which for me, as a lecturer here, working day in and day out with students in the social justice space, is simply inspirational stuff. This evening, however, we'll be hearing specifically about GreenLaw's important work in the ongoing review of the EPBC Act. And I won't say much more about this, but we'll point you in the direction of GreenLaw's website, which I hope is publicly available now, Annika, is that right? Yes, yeah. She's nodding. Good. So it's greenlawnetwork.org. And when you get there, you can download the 3 submissions the group has made on the Act, 1 to the Senate Standing Committee looking at the climate trigger, and 2 to the independent review, which we'll hear more about this evening. I'll just mention the names of the student authors briefly, as they've done such phenomenal work. There's Annika, of course, but also Andrew Ray, Nicholas Bulbeck, Sarah Norgrave, Shelby O'Connor, Charlotte Nikolovsky, and Bridie Adams. They've all contributed in some capacity to this research, some of which has already been published in Australia's peak environmental law journal, the EPLJ, which is just an extraordinary achievement. Finally, from my perspective as the LRSJ director, can I just say that GreenLaw is in many respects a model for what the program will need to do as we move increasingly into the environmental justice space. Climate change, as we've often heard, is the ethical, political, economic, and geopolitical challenge of the age. How we position ourselves to confront this as lawyers and advocates and legal academics working in the law reform and social justice space will determine our relevance or irrelevance in these challenging times. GreenLaw gives me hope that we're on the right path, and hope, as we know, is something of a precious commodity at the moment. With that, I'll hand over to this evening's moderator, Professor Jamie Pittock, also from the Fenner School, to introduce the panel. Jamie.
Thank you, Matthew. As Matthew said, I am a professor at the ANU Fenner School of Environment and Society. I congratulate the ANU College of Law on 60 years of excellent teaching, research and service for a better society. And I'm delighted to be the moderator for tonight's discussion. Before we proceed, I'd like to share a few housekeeping notes. Firstly, our webinar is being recorded and will be available on the multimedia section of the ANU College of Law website and the YouTube channel later this week. We welcome you. We have around 100 participants so far in tonight's discussion. So please ask your questions at any time using the Q&A function in the Zoom software in the bottom taskbar. From time to time, I will scan your questions and weave these into some pertinent proposition for our panel to address. I'll now introduce our very distinguished panel in turn. They'll each make a short statement and then we will have some open discussion. So to begin, it's my great pleasure to introduce the Honourable Justice Rachel Pepper, Judge of the Land and Environment Court of New South Wales, and as mentioned, an ANU alumna. Rachel, thank you.
Thank you very much. I wanted to, first of all, commend GreenLaw for the extraordinary work that they have done and the significant contribution that they have made already. I'd also like to say happy birthday to the College of Law. 60 years of producing students of the caliber who we see here tonight and who have helped create and the GreenLaw and produce the excellent work. I think Rachel Walmsley is going to talk about what's happening generally with the EPBC Act tonight. So I might let her go first to set the scene. And then I had proposed to talk a little bit about access to justice and standing. But as I said, I think Rachel Walmsley will hopefully set the scene about what's happening in the EPB space, and which is changing rapidly, probably as I speak. Thank you.
Can I now introduce Rachel Walmsley, Head of Law Reform at the Environmental Defender's Office in Australia. Rachel, thank you.
Thanks very much, Jamie, and thank you for inviting me to be on this panel tonight. I'm zooming in from beautiful Gaymagle country. So I'm the Head of Law Reform and Policy at the Environmental Defender's Office. So we're a public interest environmental law centre. And so I've been dealing with EPBC national law reform for a long time. So just to give you a bit of a snapshot of where we are today, where we're up to. So the ANU Law School's 60 years old. The EPBC Act is 20 years old. It was brought in 20 years ago with high hopes to cover matters of national environmental significance. So Ramsar wetlands, World Heritage Sites, migratory species, all those kinds of things. And when it was first introduced, if you dig through the Hansard of Senator Robert Hill at the time, it was intended to have a climate change trigger put into it at some point. Every 10 years, this Act is due for review. So 10 years ago, we had the first statutory review. Dr. Alan Hawke did extensive consultation, realised the Act wasn't working, recommended a new Act and 71 recommendations for reform, including some climate action. That report was excellent and it has sat on a shelf for 10 years with no action. Fast forward to what's happening now. So the latest statutory review of the Act kicked off in November with Professor Graham Samuel appointed to be in charge of it. It was kicked off very much in the context of, we need this review of the Act. 20 years on, it's inefficient, it's not working, but we need to cut green tape, we need efficiency and we need outcomes. But then along came the Christmas of Blackfire, the summer of Blackfire bushfires. Now, we were all actually living through a climate-induced crisis. And so extension, like the public submission period for feeding into the review was extended because, you know, we had wildlife carers out literally caring for burnt koalas. And we had this horrible Christmas season, and there was a real momentum for change, real reform, and the possibility that maybe climate change would actually get into our environmental laws. But then, of course, as you know, in February and March, the pandemic really hit. The Prime Minister announced back then the fast tracking of projects, the need to fast track projects through environmental law processes in order for economic recovery from COVID. And he also at that time started directing a bill to be drafted to devolve powers to states and territories. Meanwhile, the review continued. In July, we had an interim report from Professor Graham Samuels. And yes, it did say there could be some devolution, that could be part of it, but it also said there needs to be national environmental standards. There needs to be an independent regulator, a tough cop on the beat. It had a whole range of areas that he said he wanted to explore in this review. A stakeholder group was convened. EDO was on this group with a lot of environment groups, with the Minerals Council, the Business Council, the Farmers Federation and so forth, academics and scientists, and we all intensively worked on these ideas. But in the meantime, there was a resurrection of a 2014 Tony Abbott bill, the One-Stop Shop bill, and this was all about how to devolve the environmental responsibilities of the Australian government to states and territories. This was running at the same time as the review and very clearly preempting the final findings. In August and September, you may have seen in the media, the bill was actually rammed through the House of Representatives. Amendments about national standards and all the things that were needed were drafted by members such as Ali Stegel, but the government used their numbers to actually guillotine debate and push it through the House. And no government member actually spoke in support of the bill. It was just the rehash bill, and it was being pushed through under the guise of COVID recovery. The bill is now in the Senate, and after the third or perhaps the fourth attempt, just on Friday, it was actually referred to an inquiry. But such is the pressure to get this bill done before the review has actually finally reported that the inquiry was called on Friday, submissions were due today, and there is a hearing in Canberra on Monday, and this committee will report by next Friday. So we're talking national law reform, extremely complex legislation. They are seeking to review this in a 10-day inquiry. So it's really topical that we're having this discussion tonight. It's a really interesting moment. The final report of Graham Samuels' review was given to the Minister at the end of October. It hasn't been publicly released. All the standards that we've been working on, they have not been publicly released. The bill is in inquiry and senators are being asked to support a bill without having seen Graham Samuels' report or standards. There's great pressure to pass this bill, and you may have seen in the media as well, that's stemming from states such as Western Australia at the behest of companies such as Rio Tinto, as Sally said earlier, who have destroyed the caves this year. They are wanting to fast track approvals under the guise of COVID. We have FOI documents that show this parallel process to the review. All the evidence, all the experts and the stakeholders are saying national law reform is too important. We have to do it properly. We've had 20 years of an act. It is failing our environment. All our environmental indicators are in decline. This decadal review is an opportunity to actually do proper reform, do it properly, but instead what we're seeing is just this rushed, very, very brief bill about devolving powers to states and territories. So I'd summarise by saying I think national environmental law reform in the age of climate crisis is actually on a knife edge at the moment. It could go either way, and it's literally changing by the day at the moment.
Rachel, thank you. Can I now introduce our next panellist? Annika Reynolds is a Bachelor of International Security Studies and Laws, an honours student here at ANU and a founder of GreenLaw.
Thank you very much, Jamie. Yes, as we've been talking about quite a bit actually, I am the founder of GreenLaw, which for those of you who don't know, it is, an LRSJ project that really aims to connect law students to NGOs and academics in the field. So it's about substantive climate justice. And one of the big projects that we did at the beginning of this year was on the EPBC Act and allegations of lawfare under the Act, which ties really well into what Rachel Walmsley was talking about in terms of these broader trends that we're seeing in the media and government about how we characterise national environmental laws. So green lawfare is the idea that public interest groups like NGOs, are bringing cases under the EPBC Act for purely political reasons, and that they're abusing the EPBC Act to prevent developments from going ahead. I'm sure everyone is thinking in their heads right now, Adani, and that's a prime example of this narrative that's been conjured up. And our review was the first empirical review that's been done of lawfare since these allegations started to be made in 2015. And what we found was that not only are there pitiful amounts of public interest cases under the EPBC Act, and I'm sure Rachel Pepper can talk to the importance of public involvement generally under, environmental acts, but there were very small cases, and we were also seeing that these cases were largely meritorious. They were having positive outcomes. They're contributing to judicial review of government bodies and ensuring accountability, transparency, and perceptions that there is not corruption happening in environmental regulation. And I can speak more to that if anyone is interested on lawfare under the EPBC Act. But the other work I've also done is as a research assistant to Dr. Peter Burnett, one of our honorary professors at ANU, who is very well respected in the EPBC space. And I was lucky enough to work with him in conjunction with the Australian Conservation Foundation to do an empirical review of decision-making processes under the EPBC Act over the last 2 decades of all the controlled actions, referrals and approvals processes. So that's when there has been a matter of national environmental significance, and the department then needs to go through the process of determining if the project should go ahead or if it is too much of an impact and should be stopped from happening. And the outcome of that research really is to add some meat to the skeleton that Rachel Walmsley has gone through, is that decision makers under the EPBC Act are not approaching matters of national environmental significance as if they are a part of the beautiful Australian landscape that we should be preserving, that should be valued. Too often we are prioritising economic and social matters over ecological values, and that goes to the heart of why the EPBC Act is not working. And it really goes to the heart of this tension between development groups and cutting green tape and green lawfare and that narrative, and the fact that the EPBC Act actually has a very narrow focus on those things that matter most to us as Australians and that matter most to ensuring the Australian environment has ongoing viability. And so I look forward to be able to discussing these things further over tonight and to getting at the heart of what kind of reform we actually need for a viable Australian environment going forwards.
Thanks, Annika. And just finally, Justice Pepper will make a statement before we get into our discussion.
Thanks, thank you. I guess I really wanted to focus on one aspect, which was this very important concept of access to justice. And I'm talking about in the context of so-called green lawfare. And whenever you hear the words green lawfare, as Annika has mentioned, either out of the mouths of politicians in media, certain media organizations, it's really talked about in the context of, well, you have these so-called activists who are interfering in the judicial process, that are interfering in economic development, that are effectively stymieing through their activism what should otherwise be projects that should go forward. Now, we know that lawfare is a myth, and Annika, I'm sure, will speak more about this. The Green Lawfare team have done some excellent empirical work on showing that there simply is no evidence. The myth doesn't exist. There are no mischievous cases. Economic development is not being thwarted. There is no evidence of any floodgates litigation. And of course, this is important because there are constantly attempts to try and prevent so-called green lawfare by denying people access to justice. And typically that is done through standing, the concept of standing, either by limiting standing or just simply getting rid of it so that people can't approach the courts in order to review decisions that the executive has made. But of course, access to justice is an aspect of the rule of law. And you have to take my word for it. There have been lots of learned speeches by people such as the former Chief Justice Murray Gleeson, Robert French, and so on, and it's been said in many, many cases. And of course, without the rule of law, well, therein lies madness. Standing, in my view, should be broad. It should be open. In New South Wales, we have open standing in almost all of the statutes that confer jurisdiction on my court. We do not have a tsunami of vexatious litigants. There are all sorts of good reasons for that, including costs as a barrier, both financial and emotional. The courts have rules that allow vexatious cases to be dispensed with, and they are exercised. That discretion is regularly exercised. So it just simply doesn't bear out. A simple statistic, I think the 2019 year, we had about 1,300 filings in the court, of which a little over 100 were class 4, which is our judicial review jurisdiction, of which only 2.9% actually made it through to final hearing. And I can tell you that there wasn't a 100% success rate in those cases. And that's with an open standing. Under the EPBC Act, there's broad standing. This, in my view, is a good thing because it improves decision-making, promotes transparency. It means that decisions are lawful, and I would have thought that we want governments to be making lawful decisions as opposed to making unlawful decisions. And of course, it improves the quality of legislation because often it's through the process of review by the courts that legislation is clarified and if need be, it can be amended through the Parliament. And critically, of course, it allows the facilitation of community participation enhances trust in public institutions. It enhances trust in public institutions such as the court, but most importantly, government. And when there's high levels of trust in government, you tend to have less litigation, less civil disobedience. So it ends up being a win-win. And of course, it has a tendency to prevent or at least limit corruption. You just have to look at the cavalcade of developers who have been before the New South Wales ICAC to see why that needs to occur. And of course, where you have jurisdictions which have a lot of corruption, particularly around environmental decision-making, you tend not to have investment. So again, it's a win-win. But I can talk about, of course, all of these matters a little bit later on during the Q&A. Thank you.
Rachel, thank you. If I can remind our soaring number of participants, now well over 100, if you would like to pose a question, please use the Q&A function at the bottom of the screen. 3 have come in already, which is fantastic. Let's start with what may be a quick one from Vivian Holmes. Rachel Walmsley, this one might be for you. What is the likelihood of the bill getting through the Senate without substantial reform?
Thanks, Vivian. I think the bill will ultimately get through the Senate. I think the crossbenchers, particularly Sterling Griff, Jackie Lambie and Rex Patrick, they're more concerned, they're not necessarily against devolution of powers, they're more concerned with the process by which this is being pushed through. So they voted repeatedly in favour of an inquiry. That was one of their conditions of supporting the bill, is to get an inquiry. They also want to see some other things like standards legislation, a head of power to make standards, and potentially a pathway for when other tranches of legislation will happen to do all the other bits. So if the government can convince them that this inquiry is sufficient and that they're committed to doing other parts of the reform, I think they will be able to get that support. But having said that, there has been a huge community reaction to the way this bill is being pushed through. And there are a variety of different groups and even some business and industry groups out there who are saying this is too rushed. We need to do this properly to have durable reform. So could go either way at the moment.
Rachel, thank you. We might move on to 2 related questions about the proposed devolution of environmental decision-making to the states. Firstly, Rod Holsgrove asks, there must be a strong case for the national government to maintain development approval powers over matters of national or global environmental significance. Could the panel comment on this? Who would like to start?
I can make a preliminary point that Thank you very much, Jamie. I completely agree with you, Rod, and I think generally there is a very strong case that the national government should maintain its powers over national matters of environmental significance. And I think too often in debates about the role of the national government in this space, we forget that the vast majority of environmental approvals are already handled by the states. The EPBC Act was not, when it came into play, it didn't radically change the landscape of decision making. What it did do was it indicated the areas that we most value. And I think there is arguments to be made that perhaps those triggers, those matters of national environmental significance need to be looked at again. Notably, there's no Indigenous heritage trigger, but certainly things like World Heritage sites, the Great Barrier Reef is a great example. There's a really strong case that every Australian has a stake in the ongoing viability of those areas. I come from New South Wales, I now live in Canberra, but I care very much about what happens to our wet tropics region in northern Queensland. And I'm sure there are many other people on this call tonight who will say the same thing. It has an impact on our economy, it has an impact on our culture, and things like the Great Barrier Reef and other major World Heritage properties have flow-on ecological effects that impact our more immediate environment where we're geographically located. So I think there are really strong arguments that, you know, getting rid of the EPBC Act and going back to the pre-EPBC Act space where the states handled almost everything is not going to produce the positive outcomes that Australians want to see from an ecological or cultural perspective.
Thanks, Annika. Would either of the Rachels like to add to that?
Thanks, Jamie. Thanks, Rod. I've just put in the chat, I hope you can access it. EDO recently, we were commissioned by the Places You Love to do some analysis exactly on this point, saying, you know, should the federal government maintain responsibility for these international obligations, or can states actually handle it? So the link I've put to our report, which is called Devolving Extinction, what we did an analysis of each state and territory law and just said, does it actually address these core standards on matters of national environmental significance? We've got a scorecard that basically says no. There's no state or territory that has legislation that actually addresses World Heritage, Ramsar, all the things that need to be addressed. And then also in the report, we've got 30 case studies from across Australia with examples of how state and territory laws actually don't address all these matters. So if you're interested in that, have a look at that report.
Thanks, Rachel. Justice, you want to add?
Yeah, I should add, I mean, and this sounds somewhat trite, but states look after states. They don't look after the Commonwealth. They don't look after the Federation. And something like climate change, obviously, you know, is travels across state borders. The current alarming rate of species extinction, again, is something that travels across state borders. But states tend to be focused on the environmental planning decision-making of those particular states. And I think it's therefore important that we do have and continue to have Commonwealth oversight.
Thank you. Warwick Giblin asked the next question, which is, do the states really want control of the EPBC Act functions? Are the states asking to water down the EPBC Act? Rachel Walmsley, is that something you've encountered in the various advisory committees you're party to?
Yes, I can answer that one. And the answer is it depends what state you talk to. If you talk to Western Australia, they're of the view that they can do the job better than the government, the national government, and they said it would be far more efficient if they just did all the assessment and approval. Whereas if you speak to other states, they're kind of saying, well, what's in it for us? We're taking on liability. We would need greatly increased resources in our environment departments to do this kind of work. We would actually have to do law reform to meet standards that I think some states have seen draft standards apparently, but the degree to which they could meet that. A lot of other states are a bit more hesitant about this. A lot of states have assessment bilateral agreements in place, but there are actually a lot of steps to go through before you got an approval bilateral agreement. And there's a whole range of issues. So I would say quite a few states are lukewarm. The Prime Minister originally announced at National Cabinet he had in principle support for this, but it's pretty clear it's mainly being driven by Western Australia. And one thing the bill is actually doing is not just devolving to state law, it's also talking about devolving to other decision makers, including local government. And everyone would have had different experience with your local councils. Some are incredibly big, well-resourced. Others are tiny and are not designed or resourced to deal with matters of national environmental significance. So it really is highly variable, and it's quite questionable where the drive to get this done in such a hurry is coming from.
Thank you. The next question might best be addressed initially by Justice Pepper from Callum Rogers, who asks, how do you shake the perception of lawful environmental protection being perceived as activists interfering with the judicial process and hindering economic development?
By facts, by the evidence, by going to the data. And I know Annika is best placed to speak to that, but the reality is that the data simply does not bear out the myth of environmental lawfare. That's the first point I would make. And to some extent, as I said, politicians and some media organizations are responsible for perpetuating this myth because it suits a particular narrative. But the reality is the evidence simply does not support it.
Thanks. And I think your paper really picked up on or focused on this issue.
Yeah, thank you, Jamie, and thank you, Rachel. I think that the next step after countering the lawfare myth was saying, well, factually, there is no lawfare, is actually stepping away from that narrative and going, okay, well, actually, why should the public be involved in environmental decision making? And there are a number of reasons for that I think are a lot stronger than us staying on that one trajectory of arguing about whether or not lawfare is happening. Because ultimately, our environment, we all share it. If a coal mine is spewing pollution into the air, it doesn't only stay in the coal mine, it affects people more broadly, it affects the environment more broadly. We all have a stake in the environment, and that's recognised in the EPBC Act. The objects of the EPBC Act talk about public involvement. The reason why we have extended standing, which was put into the Act by a Liberal government, without a massive activist uproar to force it to happen, they put it in the initial Act, was because there's a recognition that the public should be involved. And when you look at the international conventions and treaties that led to the EPBC Act, the Biodiversity Convention, the World Heritage Convention, also privilege the public's involvement, because we know that the environment isn't a closed box where only a few stakeholders are affected. We're all affected by environmental decisions, and we should all have a stake in it. And the other reason why the public being involved in decision making is really positive is the fact that if we take a step back, we live in a democracy. The public chooses and elects our leaders. We have freedom of political communication in this country for the exact reason that we want to ensure that the public maintain their confidence in decision makers and that the public are able to hold decision makers to account. And so judicial review of environmental matters is a way for the public to hold decision makers to account and ensure that they aren't, quite frankly, engaging in a corrupt decision-making process. That's the real risk when we cut the public out of this process, is decisions are made behind closed doors for major developments that are worth billions and billions of dollars. And when you have that incentive there, we know Transparency International has done a fantastic report on the coal mining process and the risks of corruption, and they did a case study on Australia. We know that the incentive to engage in corrupt practices is quite strong. And so having the public be able to provide that accountability, to be able to ask for documents and to be able to go to court and hold decision makers to account is critical to maintaining that confidence in our overall democratic process.
So Annika, David Blenko is asking a sort of follow-up question here. Do you consider that by denying access to the courts, a perverse outcome might be to encourage less desirable societal activism, such as aggressive social media campaigns, protests or cancel culture, where the merits of objections are not necessarily considered or resolved?
I can't speak in an empirical way to that, but that certainly makes sense to me. And in fact, what we saw in our lawfare study was that the majority of public, so to put it into context, unfortunately, the EPBC Act, the Environment Department doesn't regularly make public its reasons for decisions. You have to specifically request them. So there's a real transparency issue with how the EPBC Act is administered. And what we found in our review was that a sizable chunk of the public information that is now available was requested during a litigation process. And so what we really saw was that people were being motivated to go to court because they were feeling cut out of the initial decision-making process. They weren't seeing their public submissions being implemented in reasons for decisions. They weren't seeing their concerns being addressed by conditions, and that was driving them to litigation. And I'm sure Rachel Walmsley can talk to that as well, that there's a sense that litigation is already the less desirable avenue to go. It's costly, it takes time, it's really risky, it leads to all these terrible lawfare myths and, you know, discussions in the media about it. People would prefer to just be consulted properly in the first instance. And so if you then cut out litigation, I think people are going to be driven to the next best avenue for engaging in a proper public discussion about these environmental decisions. When your air is being affected, when your water is being affected, when you think that koalas are at risk of going extinct, you're not going to stop just because one avenue has been cut off. You're going to go to the next avenue. And I think that is already playing out with the EPBC Act.
Thanks, Annika. The questions are flooding in, and we've got three that are related to the interaction with international conventions. And perhaps the panel could address these together. So Sophie Singh asks, how has the federal government responded to the issue of how international obligations will be met under the Amended Act? We've got Leonard Fitzpatrick's question, is there serious discussion or concerted efforts underway about embedding at a constitutional level the principle of intergenerational responsibility for conservation and the fundamental human right to a clean and sustainable environment, similar to what we're seeing in other nations and in the UN Human Rights Commission. And then Donella Patman has followed up with, you know, if we're pushing responsibilities to the states, how can we challenge the federal government's fulfilment of obligations under environmental treaties such as CITES, the Convention on Biodiversity, and I'm going to add one dear to my heart, the Ramsar Convention on Wetlands. Justice Pepper, you look poised to respond to these important questions.
Well, I'm just going to pick one of them. I have had some look into the appetite for constitutional reform to sort of entrench or embed some type of environmental protection. I think we can probably safely say there is zilch appetite for that. We know that referenda in this country are notoriously hard to pass in any event. And I just can't see that happening anytime soon. I can't see it happening expressly. I can't even see an appetite, even at the High Court level, to somehow imply such a right into the Constitution. You just have to look at the various enactment human rights legislation that have been passed in Victoria, the ACT, in Queensland. None of them have an explicit recognition of any right to a clean and healthy environment. Countries where, there are lots of countries, I should say, where such rights are entrenched: Bolivia, Pakistan, India, Indonesia, and so on. They haven't, with great respect to those countries, necessarily led to better environmental outcomes. Just because it's in your constitution doesn't necessarily make it so. So I don't know that just having it entrenched in the constitution is necessarily going to afford you a much greater, as I said, environmental protection or outcome. I suppose one avenue perhaps, and there is a litigation has been commenced in Queensland under the Queensland Human Rights Act, which sort of is starting to head down this path, whether or not courts would be willing to interpret the right to life, which of course is contained in those three pieces of human rights legislation, as a right to potable water, clean air, a healthy environment, and so on. That's a watch this space argument. But given that we can't get them expressly entrenched in the pieces of in the human rights legislation we do have, as I said, I see regrettably zero prospect of that happening at a constitutional level.
Rachel Walmsley, I wonder if you have follow-on thoughts in terms of this question of, you know, does Australia risk flunking implementation of its international obligations if we devolve decision-making to the states?
Yes, we do. I would agree with Rachel Pepper that the chances of a constitutional right anytime soon at the national level are Buckley's, but and I will post in the chat some details about the case under the Queensland Human Rights Act. That is actually a climate change case that we're running at the moment. I'll post a link to that. Just in terms of other ways to get it in, we do actually have intergenerational equity in the EPBC Act technically, because the principles of ecologically sustainable development are in there. But again, it's a long-winded argument to try and apply those. And we're also using strategies at the moment. For example, there's legislation on the Clean Energy Climate Fund, on that bill. We've written a letter saying the human rights analysis, the statement justifying that bill, is ignoring climate change. So we're increasingly using human rights arguments and climate change in a number of creative ways, but there is that block because we don't have it constitutionally. Now, in terms of actually making sure international obligations are enforced through environmental law, the bill as drafted gives the minister a whole lot of discretion. The minister can be satisfied that certain things will be met by state and territory laws. So there's an idea that there will be these standards. For instance, on Ramsar, there'll be a Ramsar standard. No one's seen it, well, no one's seen a final version of it. So the minister will have discretion to look at the Ramsar standard, decide whether a state or territory meets that and tick it off. The federal government is hoping that will devolve their liability for that too, but I don't think it actually will. The way the bill is drafted, you can accredit policies, guidelines, things that aren't even written yet. There is absolutely no guarantee that states and local governments even will actually be able to meet these international obligations. And it is the Australian government that is the signatory to these agreements. I don't think they can walk away from their international obligations. And, you know, we will always think of always have clients asking us for creative ways to hold governments to account. And just on that point, in light of the conversation we've just had, none of our clients do litigation lightly. Like, litigation is usually a last resort when they have tried other avenues, and the hurdles to bring public interest litigation are great. And many, even if you have the EDO helping you and you have pro bono barristers and so forth, none of this is done lightly, but there are avenues that will always be used to try and hold government to account. And the pushback, the streamlining, the green tape pushback is to try and reduce public scrutiny and reduce these avenues.
Rachel, thank you. Now, Jim Donaldson is challenging us to think about Barnaby Joyce. Jim, I'd rather not, but we will address your question, which is, why do we assume the Commonwealth will protect the environment better or more than the states? Annika, do you have a view on this?
Yeah, well, Jim, you've actually raised a really unfortunate reality, and a lot of my empirical research on decision-making processes under the EPBC Act is really disheartening, to be very blunt about it. Picking up on what both Rachels have talked about in terms of valuing intergenerational equity and ecologically sustainable development, and all of these principles that we think are going to contribute to more ecologically sustainable development generally. We see that decision makers will consider all of those mandatory considerations. So ESD principles are mandatory. It's mandatory under the EPBC Act to consider international obligations. It's mandatory to consider any threat abatement or recovery plans that a threatened species had. There's a very long list in the Act, but there's no mandatory balancing that is imposed by the Act. And so what we actually see is that Environment Department decision makers will list a bunch of standard words, and at one point earlier this year, I could basically say it all verbatim because I'd read them so many times in various recommendation reports, and then go on and just approve it anyway. So things like intergenerational equity, things like the valuation principle or recovery plans aren't making a difference. They very rarely are flowing through really clearly to the conditions that are being imposed, and they almost never relied upon to reject a decision. And in fact, we've had a pitiful amount of rejections in the last decade. Almost everything gets approved through the EPBC Act. So there is a real question about whether or not the Federal Environment Department currently is doing a better job than the states would. But when we look at reform, we should also be looking at where we want to go. And I think the national government has an ongoing role in this that they can't ignore, and that the Federal Environment Department should be really spearheading things like national standards so that we see outcomes across the country. I don't think a state department is ever going to be as well placed to track and ensure the ongoing maintenance of koala populations across the country, because they're only going to be concerned and have power over one state. They're not going to be able to look at koala populations in Queensland, New South Wales, and Victoria. And that's where I think we in the law reform space need to be really pushing, is that not only do we need to see things like national standards and to see a proper leadership coming out of the Commonwealth government, but we then need to actually see follow through in how decision makers are going about, each individual case. And I think there is real space for looking at changing the mandatory considerations, changing the weighting they are given, and looking at embedding ecological values in the way that decision makers conduct their work. Chief Justice Brian Preston of the Land and Environment Court that Rachel Pepper is on has talked a lot about embedding ecological values in decision-making processes and how we can do that through legislative reform. And I think that's a critical avenue.
Thanks, Annika. We might take as a comment, a contribution here from our environmental law colleague, Alex Gardner, who says, as a Western Australian, I can cite numerous instances where the state government is neglecting protection of matters of national environmental significance. A particular example he cites is water allocations to the Peel-Harvey Estuary Ramsar wetland of international importance. And he says the state's failures are compounded by the lack of interest shown by the Commonwealth in this issue. We might actually continue on with another of Alex's excellent questions. He says, it seems to me that a huge problem is the cumulative loss from particular decisions on individual proposals. And he asks, would a proper cooperative Commonwealth state regional planning process be a better way of addressing this conundrum about who makes decisions? Can the EPBC Act be reformed to secure a rigorous regional planning process to secure matters of national environmental significance? Would either of the Rachels like to respond to that excellent and positive suggestion? Rachel Walmsley.
Yes, I think absolutely that is one of the reforms that is needed in Australia, because one of the failings of the Act is the inability to address cumulative impacts. You're exactly right. Individual project decisions always get approved because it's very hard to show a significant impact on a case-by-case basis. And there's an inability to address cumulative impacts. So certainly bioregional planning is the favoured model, particularly the Australian Panel of Experts in Environmental Law. That was one of our key recommendations, that is a mechanism to bring together a lot of evidence, a lot of data, and actually do strategic planning about which areas are best for development, which areas need to be preserved or managed, particularly in light of climate change, where you need resilience across the landscape. So I think that is a really important piece. Graham Samuel in his review has said bioregional planning is critical. He's looked at ideas for standards and requirements around that. So certainly that is something he's looking at. But again, that is being delegated to a later tranche of legislation. First, we're going to devolve powers and then we'll think of some other good ideas like that. Whereas I think that's the kind of idea that needs to be set in place and invested in now. Absolutely, that I 100% agree, Alex.
Excellent. We have Justice Pepper, would you like to add to that?
I was only just going to endorse what has been said. That's part of the problem of federation is you end up with siloing in relation to decision making. Nowhere is that, I think, better illustrated than environmental law and planning decision making. The fact is, at the federal level, there is no real account for cumulative impacts. There is an attempt at the state level, but again, that in my view is not done terribly well. So when you add those two together, the outcome is very poor. But to answer Alex's question, yes, of course it can be reformed, and it should be.
Thank you. Hannah Gyrith has come in with a key question, and I think it really gets to the issue of whether one of the problems in better environmental decision making is public access to information and public participation. So Hannah asks, in the panel's view, should Australia formally express interest in ratifying Europe's Aarhus Convention on access to information, public participation in decision making and access to justice in environmental matters of 1998? Would this aid the situation in Australia? Who on the panel would like to lead off on this?
I can, if you'd like. Yes, Hannah, I would agree. I think we should absolutely ratify the Aarhus Convention. I think, as Rachel Pepper was saying earlier, access to justice is a critical function. And the three pillars under the Aarhus Convention of public participation, the access to justice and access to information, are both areas where Australia could do a lot better, both under federal and state laws. And that goes back to that earlier Barnaby Joyce question. I don't think either level is necessarily meeting the standards that Australia should be as a wealthy and biodiverse country. So certainly I think that is an area of reform we should be aiming for as well.
Fantastic. We've probably got time to address two more questions. Here's a new topic being raised by Graham Corbett, and he says that there seems to be an overwhelming concern around regulatory efficiency. Should there be more debate around what efficiency looks like in terms of environmental regulatory processes? Who would like to take on this one?
I can put forward some
Please.
preliminary observations. Thank you for the comment, Graham. I think there is absolutely a focus on regulatory efficiency, and the reason why is I think underpinning our environmental laws is still a very human-centred approach to the environment. How can the environment serve us? What can we extract from the environment? How can we get the most money out of this deal? Economic and social matters, etc., etc. And I think fundamentally, we need to recognise in Australia that our environment has only so much more that it can give. A lot of our critical ecosystems and species are nearing breaking point, and that was accelerated by the bushfires last year. To have a more in-depth analysis of that, you can look at the Bushfire Royal Commission's report. It's a very harrowing read. But it shows that fundamentally, our EPBC Act, a lot of our state acts are still concerned really about the best way to navigate the environment to get to development, not about the best way to navigate development to preserve our environment and ensure that it has ongoing viability. And so I think we really need to be altering the objects of the EPBC Act, what the mandatory considerations are and what the mandatory exclusions are. It's absurd that we can have critically endangered ecological communities that are still being bulldozed. We have one on the south coast of New South Wales, which its name escapes me right now, but there's so little ecological community left that it's no longer viable to offset. So there's not enough to go around for proponents to actually buy up land offsets. And so they now just put money into research to make up for bulldozing it. And that to me is absurd because we've hit the level where that community will go extinct in our lifetimes because we aren't valuing it the same way that we do the money that comes out of developments. So I think we need to really alter the premise that we approach environmental decision making, so that we're not looking really at economic efficiency anymore, but we're looking at environmental viability. And then the second part of that is this government, the federal government in particular, is really concerned with getting developments approved as quickly as possible by getting rid of green tape, which I find crazy considering the Environment Department itself has had a 200 to 400% budget cut over the last decade, something absurd. They've lost almost 200 staff members. So we're seeing a lot of delays because we're actually not even funding our Environment Department properly. And so I think that's the dual challenge here, is we need to fund our Environment Department properly, because then they will be more efficient, but we then need to alter the direction of that efficiency towards actually getting environmental outcomes as quickly as possible.
Thanks, Annika. We've got time for about one more question, so I'll address those posed by Helen Cooper and also Claire Powell before I invite the panellists to make some final statements. So Helen Cooper asks, what avenues are open to challenge any devolution of responsibilities under the EPBC Act through bilateral agreements if it does pass through the Senate? And Claire Powell has a similar question, which is, how can the proposed EPBC Act be amended to ensure that the government is held to its obligations to provide the standards that Professor Samuels has proposed and have an effective accreditation system for the states? Rachel Walmsley, is that something you would like to lead off on? Just need to unmute there, Rachel.
No worries. I think at the moment an awful lot of work is happening by a range of concerned organisations to try and make sure that this bill does get some amendments in it about standards and more clarity around the process for how this is going to work. And we're awaiting Graham Samuel's final report, because he's going to provide a lot more detail on this. So in terms of, it does depend on the final wording of the bill, because at the moment, the way the bill is drafted, it's trying to make bilateral agreements more durable and lasting, i.e. harder for EDO to challenge. That doesn't mean we won't. But they are definitely trying to legal proof these agreements. They're trying to lock in the status quo. They're locking in a system that has been proven to be ineffective, and interim standards can only be what is currently required by law, which are failing. So if this bill does go through, then in terms of challenging what's happening, it'll come down to a state-by-state basis. It'll come down to what's in individual agreements, the decisions that are made and the requirements around that. So that's going to differ in different jurisdictions. And as I said earlier, I think, there'll need to be creative ways to hold the government to account, because as I said earlier, I don't believe that they can vacate the sphere of environmental responsibility through this fast-tracking process. And hopefully they're hearing enough pressure from scientists, from sustainable business, from, certain sectors of the farming community about the need to do this properly and have some certainty. Just on the earlier point, I think part of the argument is there can be efficiencies. You can get a more efficient system by investing, well-resourcing departments, investing in better data, actually doing that planning up front. Absolutely, you can get efficiencies without handing over your approval powers. So the Commonwealth should just retain their approval power as that check and balance. But there are immense efficiencies you can get in the system. And the Wentworth Group of Concerned Scientists wrote a statement on this in 2012, saying these are the ways to build in efficiency, better information, better guidance for proponents. This is how you do it without handing over powers. So hopefully there's enough pressure coming through this inquiry that it'll be very difficult for the government just to race ahead with the devolution without any of these other checks and balances actually being put in place.
We have such an enthusiastic audience. There's been a flood of questions, and I'm sorry there's about 10 really erudite comments that we will not get to in our final minutes. However, I'd now like to invite each of the panellists to make a brief closing remarks, perhaps starting with Justice Pepper.
I guess I would work with the principle, if it ain't, particularly in relation to access to justice, if it ain't broke, don't fix it. At the moment, we know that access to justice promotes a whole bunch of goods. So I would hate to see that thrown out through this so-called reform process. And I just want to, I guess, end with a quote that came from the case of Neil and the Queen, which is a celebrated remark by Justice Murphy, who stated that Mr. Neil is entitled to be an agitator, and that if he is an agitator, he is in good company. Many of the great religious and political figures of history have been agitators, and human progress owes much to the efforts of these and the many who are unknown. So again, I would urge the government to continue to allow a space for agitators.
Thank you. Annika, your closing comments, please.
Thank you, Jamie. I would echo what Justice Pepper has said, that public involvement in the EPBC Act is critical. These are, I think, for us as Australians, I think we should be treating this a little bit selfishly and saying, no, this is our Great Barrier Reef. This is our wet tropics of Queensland. This is our Blue Mountains Heritage Site. These are our koalas. These are the things that we love about Australia, and we should be involved in the decision-making process to see them preserved for ourselves and our fellow Australians and for our children and grandchildren. And I think there is a lot of hope in this space, as much as the current trajectory of law reform is very concerning. The movement by Graham Samuels to look at national standards is something that we should be really supporting. For too long, the EPBC Act has been about process and not about substantive outcome for our environment. And moving towards actually putting in set standards and goals to be improving environmental outcomes, not just preventing no net losses, is something that we really need to be doing with how we are seeing continuing ongoing biodiversity decline and how we know that climate change is going to contribute to that decline in the long term. So there is a lot of hope in this space and to be pushing for national standards and accountability. And I think there is growing recognition that we need to be working with our environment, not against it.
Thanks, Annika. Rachel Walmsley, can you leave us with some uplifting and optimistic ways forward from here, or is it going to be the hard grind of legislation process?
Well, you know, my kids and my puppy are about to arrive home from soccer shortly, and they've got very strong views on national law reform. But we do talk about it a bit. And we've talked about the fact that under current laws, you know, koalas in New South Wales could be extinct by 2050. So their kids might not see a koala and things like that. And, you know, kids just get it. And so I think you do need to remain positive. And while I have been very, very critical of the current process and the inquiry in this bill and the politics, because it is exasperating because so many environmental issues at the moment are 95% politics and 5%, you know, a scientist gets to pop in a fact. This bill that's going through this inquiry isn't the end of the story. Like, there is so much to be done. It's not just a matter of will the feds do something, or can they hand it all over to the states and that government, it's that government's problem. I think we really need reform at the national level, at the state level. We need local level activities that everyone can get engaged in. And I think there is a really enthusiastic, great love of the environment from Australian communities. Like, I work with the Places You Love Alliance, which is a group of all the national environment organisations, and there are millions of members across Australia who all want better laws to save the places you love. And there's so many people working on this and so many great scientists and great minds, and there's actually a lot of commonality. So I think it's important not to lose heart when there's ridiculous shenanigans in Parliament and when you have ridiculous submission processes and inquiries. I think you absolutely have to persevere because it's too important not to.
Thank you, Rachel. Thank you, everybody, for joining this evening's event, the EPBC Act, Federal Environmental Reform in an Age of Climate Crisis. I'd particularly like to thank our wonderful panel who have entertained us with these thought-provoking discussion. The Honourable Justice Rachel Pepper, Judge of the Land and Environment Court of New South Wales, Rachel Walmsley, Head of Law Reform at the Environment Defender's Office, and Annika Reynolds, current Law and International Security Studies student and founder of GreenLaw. A reminder that a video of this event will be available on the ANU College of Law website, as you will no doubt want to watch it again to discern every tidbit of insight. While you're there, don't forget to join the mailing list for the College of Law to stay up to date with future events just like this one. A reminder that you can follow up on some of the information raised on tonight's panel by going to greenlawnetwork.org and seeing the excellent work of the College of Law students. And you could also go to the EDO's website, Environment Defender's Office, to access some of their research and submissions on this important topic. Lastly, congratulations again to the College of Law on its 60th anniversary and fine work. Thank you, everybody, and good night.
Thank you very much, Jamie. And could I just say very quickly, I know that there are a lot of environmental lawyers and other people working in the space. If you are keen to be involved and to support law students doing the kind of substantive law reform work that we've been doing with GreenLaw, I'm just going to flick the GreenLaw email into the chat, and I'd be more than happy to have a chat to you about being involved in this space. It's something that I know all of our academics at ANU have loved being a part of and have felt it's been really fulfilling, and it's great to be able to mentor the next generation of lawyers that will potentially be doing what Rachel is doing now in the EDO. So a lot of cross-generational collaboration is fantastic. So please get in touch if you're interested.
Thanks, Annika. Thank you, everybody. Good night.
Good night.
Thank you.